Welcome, friends, to the Probate Nation. My name is Richard Ruddy. Tonight, you will learn the basics of probating a Texas estate, from where to begin your probate journey, the legal and tax stops you will need to make along the way, and when to deliver the estate to the beneficiaries. You know, probate is very much like traveling on a slow-moving steam engine train, which calls to mind the train trip many years ago of a famous U.S. Supreme Court Justice, Oliver Wendell Holmes. When approached by the conductor to confirm passenger tickets, Justice Holmes could not find his. The conductor, recognizing who he was, said that was not a problem, but Justice Holmes, as you might expect, dissented. While he had purchased a ticket, he needed to know where he was going. We are fortunate to have with us tonight Job Jackson, a Texas estate and probate attorney who knows the ins and outs of Texas probate. He will share critical steps to be addressed and stops to be made in the course of any probate journey. But first, let me tell you about Job. Job is a shareholder with the Texas law firm Langley and Banach. His practice focuses on estate administration as well as estate, trust, and fiduciary litigation. Prior to entering law practice, Job had the privilege of serving as a briefing attorney for Justice Marilyn Bernard of the Texas Fourth Circuit Court of Appeals in San Antonio, Texas. Job, welcome. Thanks so much for sharing this time with us and the Probate Nation across the country. Before we jump into this topic, though, with all those YouTube videos out there on just about every topic, so many folks like to do it themselves these days. Is Texas probate something a person can do on their own, what we call pro se, without an attorney?
Well, thank you for having me today on your program. And to answer your question, in most cases, no. Texas has pretty strict regulations against the unauthorized practice of law, and anything that would require you regarding an estate to go before the court and, for instance, put on evidence before the court, you need to be a licensed attorney to do that. So there are limited probate options for someone acting pro se without an attorney.
Well, that's important to know as our viewers begin this show, and the discussion that follows will serve as what I would consider an excellent introduction to the process before someone seeks out the assistance of a Texas attorney of their choice. So let's take a look to talk a little bit about what court actually oversees Texas probates.
So a lot of that's going to depend on the county in which your probate is opened. Now, the most common venue for a probate in Texas will be the county where the decedent last lived prior to their death. And so if that were in a larger county, like say Bexar County, where San Antonio is located, the estate would be in a statutory probate court, where all that judge handles is probate actions and guardianships. Now, if you're in a small rural county on the other end of the spectrum, you could be in front of a constitutional county court, where your county court judge might not even be a licensed attorney. So what court you end up in front of really depends on the size of the county where you're doing the probate.
Well, let's step back for a second, though. Are there different options available to probate an estate in Texas? This is generally kind of the big picture before we get into the details.
Absolutely. Absolutely. There are different options. Some are certainly better than others and more frequently used, but there are a few different types of options for probate in Texas.
And what are those options? If you could just kind of highlight those very briefly before we get into the details.
Sure. So the most common type of administration in probate in Texas is probating a will and having an independent administration. That means that's going to be a probate with following the terms of a will with limited court involvement. It's the fastest and most cost-effective type of probate. You can have a dependent administration with intestacy, which would be where someone passes away with no will and their assets pass according to a statutory scheme. And the courts really monitor those probates where you have to ask for permission to do just about anything with the estate's assets. And you have a muniment of title, and you have a small estate affidavit, and then really the least common is an affidavit of heirship, which is an older option to deal with transferring real estate in probate.
Now, does the existence of a will, and we're going to talk about whether you have a will or don't have a will, but does the existence of a will have any bearing on the probate option to be used in an estate?
Yes. And the good news is usually a will, if it's prepared in Texas especially, is going to appoint an executor with independent administration, which is going to save a lot of time and money throughout the process. But if someone does have a will, that also gets rid of options like a small estate affidavit or an affidavit of heirship, because you have that will that needs to be probated to deal
Okay.
with the decedent's assets.
So let's go ahead and talk a little bit about probate with the will. First off, we have to have a will. So where do folks typically keep their wills?
Most common places to find it would be in usually someone's home office, and home offices are much more common now than they used to be, in a filing cabinet or a safe at the house. Um, More traditional places to have kept a will would be a safe deposit box at a bank. You see that typically with older individuals. In some instances, individuals will deposit their will with the county clerk where they live. That's an option. Some people don't like doing that because it also can make it arguably a public record at that time. And lastly, a common way for folks to leave their will would be in a will bank at the drafting attorney's office.
Okay.
But that's becoming less common than it used to be.
Now, we have seen a lot of clients who have wills in a safety deposit box. How can they get access to that will if it is in a safe deposit box, in Texas at least?
Well, unfortunately, it's not as simple as just going into the bank branch where you knew they kept the safe deposit box and asking to give it a look. It's not that easy. The banks have a lot of regulations that they follow and aren't just going to let you look at it. But the Texas Estates Code, which is the statute that deals with probate in Texas, has provisions for you to get a court order to authorize your access to go into a safe deposit box. And the banks almost uniformly respect that. And that's typically the route you go with to try and find a will in the safe deposit box.
Now, okay, we're going to look for a will. Tell me, though, what constitutes a will in Texas that can be admitted to probate?
Sure. So the most traditional will that comes to mind is a typewritten will. Think computer generated using Microsoft Word that is typed up. And that type of will, to be valid in Texas, just needs to be signed by the decedent and have two witnesses attesting to the testator's signature. What's very common with especially a professionally prepared typewritten will, is that there will be a self-proving affidavit, which is sworn to by the testator and the two witnesses, which really eases the probate process later on down the road after the decedent's died. Texas also allows for a holographic will, which is a will that is completely in the decedent's handwriting and just needs to be signed by them to be valid.
Now, if there is a will, does the will have to be probated in Texas?
If you want to transfer assets from the decedent's estate and move things around, then yes, you will need to probate that will within the time required by law to do so.
Okay. Well, we talked about a will. Let's talk about what unfortunately we see all too often is someone dies without a will. What happens when someone does die without a will in Texas?
Sure. So if you die without a will in Texas, you're considered to have passed intestate, which really just means dying without a will. And you can still go through probate. There's a process to pass your assets on to your family, but that's going to go by statute and the statutory scheme of intestacy. And there are a lot of rules that govern that pretty strictly, where your assets go after your death.
So I think that's what my next sort of question in this thought process is, then how are assets distributed from an intestate estate? So what you're telling me, though, is Texas, like most states, has basically written a will for you if you don't write one for yourself.
Correct.
Yeah. I think one of the challenges that people have, which is the next thing that comes up in our discussion, is people might not be happy with how things are going to be distributed if they rely upon the intestate statute. So for instance, if we have a blended family where we have kids from husband and wife each have kids from prior relationships, does that create complexities as far as how things will be distributed?
Absolutely. Absolutely. And dying without a will in Texas can get really tricky because we are a community property state, which means that you really, during your marriage, have two different types of property. The community is property typically acquired or income earned during the marriage where your spouse automatically owns half of it, and separate property. And dying intestate in Texas can have kind of unique results on what happens with your separate property, especially, and also in a blended family. I just will use this example if you are married, for 30 years and you have no children with your spouse and you pass away, and let's just say 15 years before you died, you inherited a ranch from your grandmother, mother, whoever. Our natural inclination would be, well, surviving spouse inherits everything. But that's incorrect in Texas. Actually, in that circumstance where you had no children from the marriage and separate property, the decedent's wife would not inherit all of that ranch. A part of the ranch, that separate property, would go to the decedent's siblings, or if there are no siblings, parents, and kind of go through intestacy. So you can have these unintended consequences if you don't have a will with intestacy in Texas.
So we want to be careful about that. I really do want to encourage folks to get a will prepared. Now, are there any special rules as to who can qualify to administer an intestate estate?
Yes, you have to be, in the broadest sense, suitable to serve in Texas under the estates code. Mainly, you can't be a convicted felon. That's kind of a big disqualifying factor. But you need to be someone that the court finds suitable. And the estates code has its own list of priority for who should be serving as administrator. If a will, for instance, does not dictate, I want John to be my administrator as opposed to Sally. So the estates code sets out that priority of options for you.
Okay. Well, look, in order to avoid the full probate process, what are the simplified probate options available to probate an estate, whether you have a will or whether you don't have a will?
Sure. So if you have a will, the primary simplified method of probate is what's called a muniment of title. And what that effectively does is you probate a will without appointing a personal representative of the estate, and you end up with a will that, in effect, operates as a deed. And you really only want to use this if you just have real property in the estate. If you have a car where you need someone to transfer title or bank accounts, you're going to want that personal representative to deal with that. So a muniment of title would not be a good option. The other two kind of simplified probate options where you have no will is you can do a small estate affidavit, which is designed to handle estates with assets of less than $75,000. And then also in certain circumstances, you can do a recorded affidavit of heirship. And that's an older method of transferring real property by recording heirship information in the deed records of the county where land is situated.
Okay. Well, look, we've talked about some different options here, and I want to get into the regular probate process and how we start that. So whether there's a will, let's just talk about that. If there is a will, how do we start the probate process, the regular probate process?
Sure. So if there's a will, and certainly in Texas, going back to our lack of pro se options, you want to hire a competent attorney to represent you to probate that will, but you will be filing an application to probate in the appropriate county, which is typically going to be where the decedent passed away and where they lived at the end of their life. File that application to probate in that county in the appropriate court. And once you do that, the court will post notice, really actually on the courthouse steps of this application to probate. And about 2 weeks after that waiting period, you can have a hearing to admit the will to probate and get an executor appointed.
Okay, so the application process takes a little while to to ripen such that we then, at that point, the judge can actually appoint somebody. Now, what about if I don't have a will? How do I start the probate process without a will?
Sure. In a lot of ways, it's going to look similar. You'd be, in this point, filing an application for letters of administration. And typically alongside that is a application to determine heirship. Because without a will, you're going to have an intestate probate, and the court is going to have to determine judicially who those heirs are so that they can apply the statutory scheme to this decedent's assets. In a lot of ways, that process is going to be similar. You file the letter. There's a little bit of a waiting period with notice. There's different notice requirements for letters of administration for the presumed heirs. And you ultimately have a hearing, the court appoints an administrator, and then you can begin the probate process.
Okay, so that we got ourselves appointed. We have our certificate that says we are now in charge. Do I have to file an inventory of some kind?
Yes, whether it's an independent administration, which again is where you have less court oversight, and a dependent administration where you have, absolute court oversight in just about everything you do, you're going to have to do three things common in both of those types of probate. You're going to have to give a notice to creditors, you have to give a notice to beneficiaries, and an inventory must be prepared of the estate's assets.
Okay. Now, once I've done that, what about, accounting? Do I have to file an accounting showing what I received, what I've dispersed, and do I file more than one of those?
Sure. So in an independent administration, you actually do not have to file an accounting unless requested by a beneficiary. And that typically comes about, by statute, you can't ask for an accounting until 15 months have passed after the letters testamentary have been issued to the independent executor. So really in that context, it comes up with the beneficiary saying, hey, it's been 15 months. What's happened? Why are we still administering this estate? So you can demand an accounting, which in that instance, one of the things they'll have to disclose to the court is why there's even a need to continue administration. In a dependent administration, it's different. There's a requirement for an annual accounting by the dependent administrator describing every activity done by the administrator during that past year. So every piece of property received, every payment out, all has to be accounted for on an annual basis.
So the inventory, though, the due date for that is generally 90 days after you get formally qualified. And then,
Correct.
And then depending upon the type of probate you're undertaking, you'll have to file an account. You may have to file an accounting about 15 months out. Is that correct?
In an independent administration, correct. In a dependent, you need to do that accounting within 60 days after the first anniversary of being named administrator.
Okay. All right, so let's talk about how do I identify and notify beneficiaries?
Sure. So if you have a will, hopefully the will name who the beneficiaries are going to be in it. Sometimes you will have a class gift. I leave X to my grandchildren. You'll need to do some investigating to determine who the grandchildren are. Good sources are always surviving family and friends. In this day and age, social media is becoming a resource to locate folks. In some heirship, certain situations, it makes sense to hire a genealogist, especially when, a generation or two of folks have predeceased the decedent. You really need to dig deep to determine who the heirs are. Because I'll stick on the heirship situation. To have an heirship determined by the court, you need two independent witnesses to do that. So having a genealogist, and really digging to find those family friends who could testify to that is very important.
Okay, the next thing on my list of things to talk about is how are creditors alerted, okay, that someone has died and they may need to make a claim?
Sure. So one of the first early steps you have to do in any estate, whether it's a dependent or independent administration, is publish a notice to creditors. And That has to be done in a newspaper of general circulation in the county where the probate is being done. And so you will publish that general notice to creditors. Now, if you have a secured creditor like a mortgage lender, you have to send them direct notice that the decedent has passed away.
Okay, and now, once we figured out we've received the notices of the debts, then I guess the next step, as we've talked about, is we need to either pay the debt or negotiate, some sort of thing, or otherwise dispute the debt, in which case we get the court involved. So let's talk about resolution of disputes. What happens if there are disputes in the probate process, either with creditors or with beneficiaries? How are those things resolved?
Sure. So if you have disputes that you just could not work out outside of court, especially with creditors, you can have a lawsuit filed that would be in front of the probate judge, who would have jurisdiction to hear those claims and resolve any of the disputes regarding it. So, if you have a creditor claiming a debt based on a breach of contract, that probate court could have a breach of contract lawsuit heard in front of it. So, especially in a statutory probate court, they have jurisdiction to hear a very wide variety of lawsuits and disputes, as long as a personal representative of the estate is involved.
Okay. Now, we've taken care of all the bills, we've filed our inventories, and all the creditors are good to go. We're actually ready to go ahead and wrap this estate up. How do we go about making the distributions and close out the estate in front of the court?
Sure. So if you have an independent administration which has less court supervision, I'll start there. You really just distribute all the assets, and you don't actually have to formally close the estate. It is optional. If you want to close it, just really want it formally closed, you can file really for a judicial declaration discharging you of your duties and obligations. Typically, that's not done in independent administrations just because you don't have an annual accounting requirement. And especially in Texas states where you're more likely to have minerals involved, it's useful to leave the estate open, just so if something is discovered in the future, there's new activity, you have a personal representative there on the estate's behalf ready to go and take care of it. Now, dependent administration, where you have annual accounting requirements and a lot more expenses involved, you do want to go ahead and close those estates. And in that instance, you'd file a closing action with the court seeking also a judicial discharge. And you'd have to do a final accounting of all the estate and its assets as well.
Okay, so most probates that we talked about generally take, at least 6 months and can take longer. Let's talk about, I'm serving as a fiduciary. What kind of fees would a fiduciary be entitled to?
Sure. So if you're dealing with a will, 99% of the time, a will will either do one of two things. It will say no compensation, and that's pretty typical if the executor is going to be a child or a sibling. Just thinking, hey, family's not going to charge family. If it's going to be a third party, it'll typically say reasonable compensation. And the estates code has what's called the 5 in, 5 out rule for what is considered reasonable compensation for an executor. And that really kicks into place if there's no mention of compensation in the will, or they just say reasonable. A dependent administration, of course, there is no will, so you just go straight to the 5 in, 5 out rule.
Okay, we're starting to run out of time, and because there's so much
Sure.
information to pass along here. Let me get to your closing comments, okay, as far as how, things that you want to share with us about Texas probate and things that people ought to remember from the show tonight.
Really, ahead of time, estate planning is just very important. It is shocking how many people do not have a formal estate plan when getting an estate plan has become so much more cost effective than it has been beforehand historically. But when you do find yourself in the process of being to probate a will, be sure to get kind of competent legal advice at the beginning. Sometimes you really do get what you pay for, and having someone who can navigate the local court and effectively help you manage the estate and bring it to a close with as little cost as possible.
Well, Job, I want to thank you on behalf of the Probate Nation for visiting with us, for sharing an overview of Texas probate law and, your advice as to what to do and, frankly, what not to do if probate is necessary. And, of course, the need to have a Texas attorney handle the details of any probate, valuable information, and really a great public service to our Probate Nation viewers. So, again, thank you so much for taking the time today.
Thank you for having me.
Without a doubt, folks, probate can be complicated and confusing. Tonight, Job has given you an excellent introduction to the Texas probate process, including steps to take and pitfalls to avoid. But again, I would be remiss if I did not note that there are many legal documents to be drafted, and as we learned this evening, Texas courts will require an attorney to be involved when filing probate documents. So I encourage you to seek the advice of an attorney at the outset of your probate journey. Their guidance will help you avoid unnecessary work, delays, and additional fees and costs. This brings us to the conclusion of our show tonight. Hope you found it helpful. Replays can be viewed on the Probate Nation website and YouTube channel. And if you want to receive monthly probate tips, please sign up for our free Probate Nation newsletter at probatenationnews.com. Many thanks for tuning in. Until next time, I am Richard Ruddy, and this is the Probate Nation.